can't bring Kilmar home again. He's already in the United States. So now you can't satisfy what you wrote in your complaint. Even if we say everything is true, you got what you wanted. Illegal border crossers released into the US compared to more than 62,000 in May 2024. 62,000 1 year ago, now zero. Weird how that happened.
We really encourage illegal aliens to take advantage of that. It's incredibly generous of US taxpayers, but it is also make sure that our law enforcement is safer. These arrests can be very dangerous to make.
Trump's DOJ now demanding that Judge Zenas dismiss the Kilmar case. You remember this one, and we've been covering it a long time because this Judge Zenas, an Obama appointee, has kept this case way beyond her limits, and now it's time for it to go. Trump submitted this from the DOJ directly to the court. They say, all right, Judge, listen, 3 months ago, we got here with Abrego Garcia, a removable alien with no right to remain in this country. He was removed to El Salvador. You remember that. Abrego Garcia, his wife, Jennifer Vasquez, and the child sued Trump seeking declaratory and injunctive relief, citing an immigration judge's 2019 grant of withholding of removal to that country. Now, I like how they didn't say El Salvador because it's for Guatemala. Now, the relief sought was the return of Abrego Garcia, leading this court, Judge Zenas, to grant an injunction to facilitate the return of Abrego back into our country. Now, plaintiffs, Abrego and Vasquez and the rest of them, remember, Trump did bring Kilmar back and hit him with a bunch of charges, and he's now being prosecuted for a variety of them and unlikely to get out of custody since, human trafficking carries, you could make the argument, 10 years per human, and he transported illegally a lot of humans and a lot of kids too. Now, they have gotten the relief they sought. He's back in the United States, probably not ever getting out of custody ever, saying because they have taken extraordinary steps and effectuated Trump Abrego's return to the United States. And since he is now here, your claims and everything that was brought by the ACLU gangbang lawyers in this case is now moot. And you, Judge Zenas, you lack subject matter jurisdiction and you have no choice. The rules say 12B1. You must dismiss this case and do it now. Writing, for the purposes of a motion to dismiss, their allegations are assumed to be true. So Team Kilmar, we're going to give them the benefit of the doubt as we do our analysis. They say, let's talk about it. Okay, Abrego Garcia is a citizen and he's a native of El Salvador. His so-called wife, Jennifer Vasquez Sura, and his wife are his wife and child, AAV, right? Two other kids that in her orders of protections where she was begging judges to stop her from being beaten because Abrego was so violent towards her, she called them her kids, my kids. He was attacking her family. Abrego Garcia violated U.S. law by entering the country illegally without inspection in 2011, hung out in our country forever, never ever tried to get legal status until recently. In March 2019, Abrego Garcia was served a notice to appear in removal proceedings. They said, you're inadmissible. You're an alien who is present in this country and you're not allowed to be. And during a bond hearing, in fact, in April, Abrego appeared for his first hearing in immigration court. During a bond hearing, U.S. Immigrations and Customs Enforcement, ICE, stated that local police had verified through a confidential informant that Garcia was an active member of MS-13. Also had the gang sign on his knuckles. Also has a bunch of witnesses who are now going to be testifying against him, who are co-conspirators essentially, who all will confirm the same. And thus, he's a danger to the community. And so ICE provided a gang field interview sheet that was generated by the police department, which explained exactly why this guy's a gangbanger. After review of the evidence, an immigration judge denied bond. That's due process. You mean a judge looked at the case, reviewed all the facts, and denied him bond? That's due process. Someone wake up Van Hollen. Abrego Garcia then filed an application for asylum. Right after, he's like, wait, I gotta go? I'm being removed? This is crazy. He files an application for asylum, withholding of removal, and protection under the CAT, Convention Against Torture. Then he had an individual hearing that took place on August 9th, and he had another hearing on September 27th. The immigration judge found that he was removable, but in the conclusion of the document, look, I still can't believe the DOJ has not caught this yet, but they even say the Barrio 18 gang was targeting him and threatening him because of his family's pupusa business. The judge in the order, 10-10-19 order, okay, he had two hearings, then Judge David Jones on 10-10-19 came out. In the concluding paragraph, he says, withholding applies to Guatemala. Why? Because the family was in Guatemala presently. They moved. They left El Salvador. The family was in Guatemala. They're under attack there, so he cannot be sent there because they have their pupusa business now in Guatemala, not El Salvador. But anyways, DOJ doesn't care. They say it's moot. You have no jurisdiction anyway, so go. On March 12th, Abrego was stopped by ICE officers and he was removed and detained in CCOT. On March 24th, ACLU, Vasquez, and the rest of the gangbang lovers from the Democratic Party all sued Trump. They said that they're violating Abrego's claims for withholding of removal. And remember, the DOJ basically adopted this argument because Iraz Ruvani, a person who used to work for the DOJ but has now been relieved and fired, was the person who went into Judge Zenas' courtroom and made some of the worst arguments a lawyer has ever made, which is admitting you were wrong, admitting fault when there were 50 good arguments as to why you were not wrong. Remember, Iraz went in there and he said, Your Honor, I can't explain. It's clearly a withholding of removal for El Salvador, even though the order never says El Salvador in the withholding of removal sentence at all. In fact, the conclusion references Guatemala. So a competent lawyer, even if you say that that was not right, would have at least made that argument. Oh, sorry, we were following the conclusion, because that's what the judge wrote, and the logic of the entire opinion confirms that. And they didn't do that because, of course, this was a poison pill. I would bet money that Iraz Ruvani ends up at some big lefty law firm very soon because his job is done. In their complaint, plaintiffs requested this court order Trump to take all steps to return Abrego Garcia to the United States. In fact, they moved for a TRO, and this court construed that as a preliminary injunction, ordered Trump to, remember, facilitate the return of Kilmar. John Roberts even granted the application up to the Supreme Court, and then on April 10th, the Supreme Court upheld the directive, saying you have to facilitate the return, and remanded the case to Zenas to clarify what that meant. What does effectuate mean, giving due regard to the deference owed to the executive branch to conduct foreign affairs? Yeah. On remand, the district court amended the preliminary injunction and ordered Trump to take all steps to facilitate Abrego coming home as soon as possible. And they're going to say, we did. Now, here's what the rules say. When you're faced with a motion to dismiss under 12b1 for lack of subject matter jurisdiction, you have to analyze this. And if the facts fail to support your jurisdiction, you have to dismiss. Here's the argument. Now, you, Judge Zenas, as a court of limited jurisdiction, you only have certain power. You can't hear every case that comes in front of you because you want to. You possess only that power authorized by the Constitution and statute, and you can't expand that power by judicial decree at all. And if people are going to sue, there's got to be actual controversy that you can address. Now, in their complaint, the ACLU brings 5 claims, and the gangbang team claim that Trump violated U.S. code, the due process claims, 2 due process claims, an APA claim, and saying that Trump was acting arbitrary and capricious. They say at the end of each claim, right, they say, well, you have to be able to solve like each one of these claims. You have to be able to address it. At every conclusion, they say, immediately order Trump to return Abrego to the United States. They go, he's here. What's your problem? So they reflect the same central request to their relief. They say all of this is in violation. They want the immediate cessation of any money being paid down to CCOT. And guess what? After extensive diplomatic efforts on your behalf, we have successfully achieved the requested relief. And since there's nothing else you can do to grant relief, since it's all granted, you got to dismiss. Now that we have facilitated the return, now there's nothing more. We've complied with the court order. We've successfully facilitated his return. And because they have received complete relief, everything that they wrote in their complaint, this court no longer has any effective relief that they can offer. Therefore, there is no longer a live controversy. You can't bring Kilmar home again. He's already in the United States. So now you can't satisfy what you wrote in your complaint. Even if we say everything is true, you got what you wanted. So this court only has jurisdiction if there is an actual ongoing controversy. While one remained after the court entered the injunction, none does so after he came back. And so therefore, if you do anything else on this case, it's going to be advisory because you can't solve anything. Their claims are moot, and all of the discovery that you ordered, Judge, are also now serving no further purpose. You granted expedited discovery to say, what have we done to bring him back? But guess what? He's back. We got complete relief. He's in the United States. You no longer need discovery to reveal whether we're working with you. We told you we were trying to resolve this, and we did. Now, alternatively, even if this court concludes that this is not moot, it should dissolve the injunction that issued. We satisfied everything you wanted. The party requesting dissolution bears the burden of establishing significant changes. There is a significant change here. He's returned. Everything you wanted has been granted. Now, he's being charged with multiple felonies, and he's probably going to have stacked convictions at the end of it, but he's here. And that begs the question about attorney malfeasance or misconduct. Like, you bring him back. Maybe he could have gotten out of CCOT and been a free man down there. Now he's probably going to be in federal custody for the rest of his life, hopefully. Saying is impossible because its requirement has been accomplished. Any attempt at continued enforcement would be a waste of judicial resources. That's okay. That's their job right now. And because their claims are moot, Judge, you must dismiss their complaint. Signed by Drew C. Ensign, over for the DOJ, demanding a dismissal of the Kilmar case. case. And we also saw there's a lot of other things happening. So Kilmar is back being charged. We've got Homeland is now reversing itself. Remember, Trump came out and he's like, well, we like the farmers and we like the hotels. And we all went, what? Then we see a reversal. This is the benefit of having the base speak up and not having rigorous orthodoxy in our party. It's actually good to have people disagreeing with each other and calling each other kooks or whatever for the time being. But it's not a party where we all just follow whatever Lindsey Graham says, right? And so the base spoke up and said to Trump, we don't like this at all. And Homeland Security reversed. White House officials said that they want ICE to now arrest 3,000 illegals per day, and they're going to continue this at farms, hotels, and agricultural businesses. All of it getting reversed. They said the president is incredibly clear. There will be no safe spaces for anybody, said Tricia McLaughlin. Said worksite enforcement remains a cornerstone of our efforts, and others reported last week that Trump might want to reverse this. Even Trump made a statement about it saying we have to do something about this, but not anymore. So back on track there. We also saw great border numbers come out. Border Patrol just released the May monthly border numbers. Stunning. Zero, count them, illegal border crossers released into the U.S. compared to more than 62,000 in May 2024. 62,000 1 year ago, now zero. Weird how that happened, and didn't even need to pass a big smorgasbord of garbage immigration reform. Additionally, another 93% decrease to the year on border crossers between ports of entry. All it takes is a little bit of leadership. Great to see it. Now, here is another California official that warns people. We saw, I think the mayor, Bass, she came out and said that the curfew was going to be lifted, but the sheriff's office came out and says, listen, if you guys get out there creating chaos, we're going to respond accordingly.
To the people of California, we are here to protect your right to speak and be heard. For those who choose to exploit public demonstrations and invite violence, attack officers, or create contact or create chaos, know this, we are coming for you. Your actions will not go unanswered. Our officers have shown professionalism, courage, restraint under intense and dangerous circumstances. I'm incredibly proud of the men and women in the California Highway Patrol. We remain unwavering in our mission to provide the highest level of safety, service, and security for everyone who lives and works and travels in the state. Thank you.
Dangerous work? That's crazy, because I heard that the media was telling us it was just peaceful everywhere we saw. Those were peaceful fireworks, those were peaceful bricks, and those were peaceful spits that were coming out of deranged liberal mouths. Now, here's Tricia McLaughlin over Tricia, Ohio, says you can help yourselves, illegals. Just download the app and deport yourselves. Save us all some trouble.
We are seeing illegal aliens take advantage of this program. So this is the CBP Home app. It's available on any phone, and you download it, you put in your personal information, and we will get you a free flight, a courtesy of the U.S. taxpayer, so generously giving that flight, as well as a $1,000 exit bonus for those who are in this country illegally. It saves U.S. taxpayers 70% because the average arrest and deportation, if that's what it comes down to, is about $17,000 versus this would be around $2,000 or $3,000. So we really encourage illegal aliens to take advantage of that. It's incredibly generous of U.S. taxpayers, but it is also make sure that our law enforcement is safer. These arrests can be very dangerous to make. It's also safer for the illegal aliens. So, I mean, our message to Gavin Newsom and Karen Bass is there doesn't need to be a single arrest. You should be telling those in your community who are here illegally to self-deport now. That way, they still preserve the potential opportunity to come back into this country the legal, right way. But if we have to arrest, detain, and deport these people, they won't be able to come back.
That's exactly right. Thank you, Tricia, for explaining it so simply. Don't have to fight about it. I don't know why they have to be so difficult about everything. Just follow the law. No one's above the law except Senator Padilla and Brad Lander over from New York, and, you know, Tishy and Fanny and a bunch of others. But we're going to continue to work on that, my friend. So we'll keep our eye on this. We've got the Kilmar case. Trump drops a motion to dismiss, demanding it finally goes away. You've got no more claims here. We'll be covering it. We'll see what this judge does to keep the case, because we know that she will.